We're ready to start. I'd just like to introduce you all. Thank you for those that have joined in. As always, we'll be recording this, so if you've missed a bit, you'll be able to view it later. I'd just like to introduce you to Eileen Scott from Garland, Hawthorne and Bray, and also someone who's a very valuable friend of SOFA, who's helped us a lot with the disclosure booklets, which you can get online, and various projects. Eileen's very kindly giving us some time today in her absolutely fantastic home. I'm very impressed. It's a beautiful place. So Eileen will be talking to us today. I just want to clarify, though, for anyone tuning in, that this doesn't constitute legal advice. Eileen is a lawyer, but we're just having a discussion today, and we'll give some resources at the end for where you can go to. But obviously, it doesn't replace the legal advice from your own lawyers or from your management staff. But with Eileen's amazing experience with discrimination and this area, we hope it'll be very useful for you today. So when we finish at the end, please ask some questions. Don't mention client names, but if you have some general questions about these issues, that would be fantastic. So I'm going to hand it over to Eileen. Thank you, Eileen.
Oh, hi, good afternoon. Now, my segment is really about employer and employees' duties and obligations in relation to disclosure of personal information. And this was based on a seminar that I did for Social Firms of Australia a couple of years ago. We've repeated it since, but my experience as a lawyer is that people are very confused about their duties and obligations in relation to disclosure of personal information. So that's what this presentation is about. It's about duties and obligations of employers and employees to each other, and I want to emphasize the mutuality of the obligations. I'm going to look briefly at the sources of the obligations on the part of both parties, because I think it's important so that people gain some kind of understanding of where these obligations actually come from. And what the aim of all of this really is that people who are employed who've got a disability, or indeed people who are employed who don't have a disability but generally have obligations to their employer has obligations to them, and we want to tease them out. Now, I'm aware that people with a disorder, psychiatric or otherwise, feel that they're not actually obliged to disclose. That's not quite the case in all circumstances. The other aspect of that, and this is where you get the mutuality of it all, is that employers are frequently unaware of their duties in relation to the prevention of disclosure, should an employee disclose, to other employees. And that whole confusion actually can cause misunderstanding, can cause resentment, and can cause harm to the employment relationship. So just to step back for a moment, it's important for people to realise that there are implied duties in an employment relationship. On the part of an employer, there's an implied duty called mutual trust and confidence. I.e., I can't do anything to my employees that's going to harm their interests, so I can't do something that would deliberately offend them, that would cause them upset. An employee has a duty of what's called fidelity, very old-fashioned term, but that means that they can't harm the employer's interests, so you can't go selling an employer's confidential information. Honesty. If I have an impediment to carrying out the inherent requirements of the job, then I've got an obligation to tell the employer. So as a lawyer, taking me personally, I need to have a practicing certificate. If I can't get a practicing certificate because of various issues, then I've got to tell the employer that. So then there's also express duties on the part of an employer to pay wages, and most importantly, to provide a safe workplace. And a safe workplace in relation to people who've got a disorder of any kind, or indeed generally, is to provide a workplace that's inherently safe, that they're not going to be bullied in. All right. Now, when we talk about the employee's obligations to disclose, then that's really going to depend on the job. So if you're a bus driver, for example, and you're on medication that affects your ability to drive, then you've obviously got to tell the employer. However, if you're an office worker and you're on medication that doesn't affect your ability to carry out the position, then there's no obligation to disclose. So the obligation to disclose is to do with the inherent requirements of the position. So it's to do with an analysis of each job that an employee actually does. The obligation on the part of an employee to disclose is balanced by the fact that an employer is prohibited from discriminating either directly or indirectly against a person who's got an attribute, and an attribute includes a disability. Discrimination is legally defined as less favourable treatment as a person with an attribute, for example a disability in these circumstances, in comparison to somebody without. And it's also prohibited before, so a prospective employee, an actual employee, or actually terminating the relationship. So balancing the employee's obligation to disclose is the fact that an employer cannot actually request information that could be used to discriminate. So if I'm at home sick, my employer is only allowed to say, "Are you medically unfit for work?" The answer is yes. They're not actually entitled, except in some very specific circumstances, to know what is wrong with me, or necessarily to know what's my long-term prognosis. So on the one hand, an employer is prohibited from requesting information that could be used to discriminate, but on the other hand, an employer has got an obligation to provide a safe workplace. So that means that an employer can ask whether or not you're on medication which would prohibit you from carrying out the inherent requirements of the position. And this doesn't necessarily only apply to somebody with a disability. I mean, I was recently involved in a case where somebody who was activating highly dangerous machinery was on tranquilizers, which actually rendered him unsafe to operate the machine. So in those circumstances, an employer can either request an employee to get a medical certificate, or else get clearance to say not what's wrong with them, but that they're safely able to operate the machinery. So it becomes a difficult issue for employers to balance the obligation not to discriminate, but to balance the obligation to actually provide a safe workplace. So really, at the end of the day, it's a difficult issue which requires everybody involved to grapple with the inherent requirements of the position. So the inherent requirements of the position is obviously an objective issue. So employment consultants or others placing people in those kind of positions must know what the inherent requirements of the position actually are, must have some kind of sense of whether or not it's safe for their clients, and this applies to clients generally, to be put into that kind of position. So it really requires employment consultants to ask some really quite serious questions, and it requires employment consultants not to assume, as I know, that their clients can necessarily withhold information from employers that will allow the employer to provide a safe work